So, there was that. Okay. Okay, good afternoon. Today I will be sharing with you all, the topic will be the enter of appearance to the read. Okay. Enter appearance, the rules of the enter appearance was under Order 12, Rules 1 of the Rules of Court 2001-2. Basically, what we mean by enter appearance, basically it shows that the defendant is intended to defend their case in court. Okay. So the next question will be going to how actually an appearance can be entered in the courts, I mean by a defendant. Basically, there is either you enter by your lawyer or in person. The documents that you are filed in the court will be called memorandum of appearance. A memorandum of appearance, it needs to be signed. If you are entered by a lawyer, the lawyer will sign on behalf of the defendant. If the defendants entered in person, then which means the defendants will be will sign the document called memorandum of appearance and filed into the court. This is also you can read from Rules 12, Order 12, Rules 2. Okay, and then okay, the one point you must be understand for a corporate body, this must be the appearance must be filed by a solicitor. Okay, when this appearance must be filed to the court, it will be filed under, if you can read Rules 4, Order 12, Rules 4, 14 days after the service of the writ. For example, if the defendant received the writ by today is on the 12th, so which means within 14 days after today, they have to be filed the so-called the memorandum appearance to the courts. Okay, remember, after the filing of the memorandum appearance, the document, it must be served to the plaintiff solicitors. Okay, what happens if the defendant is late in entering appearance? Okay, the plaintiff have the options to apply for what is called a judgment in default. In short, we always call it JID. Okay. So what happens if the JID already entered against the defendant? What the defendant can do? Okay, what the defendant can do if the plaintiff has entered a JID of appearance? Okay, a defendant has to apply for the leave of the court to file the appearance if the plaintiff has already entered the JID. But then, if the defendant entered appearance after the time limit, which means after the 14 days, but before the plaintiff enter a judgment, then there's no leave need to be applied from the court. You can just file in. So which means judgment cannot be filed. If judgment already filed, you must get a leave. If judgment is not filed, that means you no need to get a leave from the court. You can just file even it's already over the 14 days. Okay. Then we come to the types of the judgment in default. Basically, there's a two types in general. There's two types of judgment. One is called final judgment, which is also a liquidated damage. What is meant by liquidated damage? Liquidated damage is the damage that or some of the money that you claim in your writ, which means it's already can be fixed, can be ascertained. So, for example, a breach of contract. So you know already the plaintiff will know how much they want to claim from the defendant. From a breach of contract, you know how much is the damage you want to claim from the defendant. So these kinds of damage, we call it liquidated damage. It is also a final judgment, which means you cannot, whatever the claim sum stated in the writ, that will be the figure that you will claim from the defendant. So it's a final judgment. The second judgment will be also called is interrogatory judgment. It's also called unliquidated damage. Okay, this kind of damage cannot be ascertained when you file when the time you file the writ. For example, pain and suffering, most will be incurred when you file a stop action, because you cannot ascertain how much is the damage from the time you file in your writ. So we call it the interrogatory judgment. Because basically this is a two type. The difference also the same. For the final judgment, final judgment is the figures that already not need to be ascertained by the court because you already fixed it, you already stated in the writ. But then for the interrogatory judgment, it requires the court to assess the money for you, for the plaintiff. That's why the best example would be pain and suffering. Okay. But then it's not in every action a judgment and default can be entered. There's a few types of the actions that you cannot just enter a judgment in default. Other than the whatever is stated in the order 13 rule 1 to rule 5, other than that, you cannot just simply put in the get the so-called file in the judgment in default in the clearance. Another one type will be the equitable remedy. Basically, equitable remedy will be remedy under the injunction, specific performance, and misuse. For injunction, okay, I will just briefly bring you along what is meant by an injunction. An injunction is when you want to file an injunction to get a judicial order directing a person to stop doing what he or she should not doing. For example, you stop a trespasser to enter a land because you know someone entered the land doing something on your land. So you are filed an injunction to stop such person to doing something on your land per se. Specific performance, basically when you file a specific performance, is you are ordered, the plaintiff is ordered the defendant to deliver a unique thing. For example, this one is very a common example, vendor and purchaser sign the S&P, but later vendor refused to sell the property to the purchaser. In this kind of situation, the purchaser can file a specific performance to order the vendor to sell the house to the purchaser. So you see, equitable remedy is the remedy that you want another person to do something. You are not necessarily you want to claim on a monetary sense. Like for example, in injunction, you want to stop a person from doing something. Specific performance, you want the defendant to deliver something to you, which is already signed under a certain agreement. The very common situation will be vendor and purchaser kind of situation. Okay, the last one will be you putting the party back into the position they were in before the contract was made. So this basically for the equitable remedy, this is the 3 types of very, very common kinds of equitable remedy. Okay, so another situation will be if the defendant was represented by a solicitor, which means the defendant solicitor already enter a memorandum of appearance, serve it to the plaintiff. In this kind of situation, even though already over the 14 days, a judgment in default appearance cannot be entered against the defendant unless plaintiff must give a notice to the defendant's lawyer 7 days notice to informing the defendant solicitor that plaintiff intention to enter a JID against the plaintiff. This you can see under the legal professional practice and rules. Okay, but then this kind of situation is only applied when both sides, which means defendants and plaintiffs, were represented by a solicitor. Okay, now what happens if the judgment in default is already entered? What should a defendant, what the defendant can do in this kind of situation? Okay, the defendant can apply to set aside the judgment within 30 days of the plaintiff serving the judgment on defendant. Okay, so which means 30 days from the day of the service of the judgment on the defendant, not the judgment date. So for example, if the judgment date is dated on 1st April, but then the judgment is only served on the defendant on the 12th May. In other words, it's 30 days from the 12th May. It's not the judgment date. Okay. But how about if the defendant already late, okay, which means it's over the 30-day period, whether or not he or she is still entitled to file a setting aside? The answer will be yes. The defendant can apply for an extension of time. However, is whether or not the courts will be given a leave to the party to file extensions of time. Some of the factors the court will become into the consideration will be based on the several factors. Is whether there is any delay in the defendant application. Okay, is whether there is any irregularity in the obtaining of the judgment and default, and also the merit of the case. Okay, just like I mentioned, that the delay in the defendant application. So which means the defendant have to be put into their affidavit to explain to the courts why they were delaying in the setting aside of the judgment. For example, if the judgment is obtained in the year 2019, now it's 2020, so which means few years. So the defendant must be explained to the court what is the reasons over these few years already, why they still until now they file the application to set aside. This is what's called in delay in the defendant applications. Okay. Then we will come to what is meant by regular judgment in default and also an irregular judgment in default. Okay. A regular judgment in default is obtained by the plaintiff normally without any procedural error. In other words, is the plaintiff is serviced in writ summons to the defendant in the correct way. I mean, if like personal, it will be AR register, company will be under the register force, duly chalked by the parties. There's nothing error in the so-called procedural error. There's no procedural error. So this kind of judgment, we call it is a regular judgment. Okay. Irregular judgment, in other hand, is obtained when there is an error in procedure in obtaining the state judgment. For example, when you serve the, when you, okay, the defects of the service of the writ or judgment to the defendant. For example, you serve the judgment to the defendant register address, but without knowing what is the letter's register address. So you just serve it, might be the register address is 10 years ago, which client given to you, but in fact they already changed it before you file your summons. So in the SN search, the register address is different with whatever the client given to you. So you are not serviced to the updated. So in this kind of situation, it might be causing the judgment that you obtain become an irregular judgment. Okay. So what is the effect? What is the effect in to setting aside a regular judgment, and also what is the effect in setting aside an irregular judgment? Okay. Okay, in a regular obtained judgment in default, which means there is no error in procedure, or the procedure is complied with, the defendant must prove there is a merit to his case. Okay, so it has to be proved to the court that there is a defense worth to be heard by the courts. Okay, there is a merit to the case. Okay, however, if the defendant can prove that there is an irregular judgment obtained, then it can be the application can be a matter of right. So because since the regular judgments have a procedure error, so in other words is you cannot prove that the defendant has accepted the judgment when obtained wrongly. So that is why we say you can prove that it's an irregularity in the judgment is as a right. But then if there is a regular, everything is perfect, then the defendant have to be prove what is the merit of the case. What's wrong with the case? There is some of the reason why in my case have to be heard by the courts, and then this judgment is actually unfair to me. Okay. However, we back it to the Order 13, Rule 8, in also one of the case I refer here is the Tuan Haji Ahmad Abdul Rahman case. We always call it Arab Malaysian Finance Berhad case. This is a federal court. It stated that whether or not the court will be give you a power to set aside or to vary the judgment, it will be in the discretions of the court. Okay. So it's a power of the court, because the court will be looking on all the aspects and anything, whether or not setting aside it should be allowed given to the defendant. So you can see from some others, the orders, Order 13, Rule 8 is regarding to setting aside a judgment. Rule 42, Rule 13, that one is setting aside or vary judgment and order. So when you want to set aside a judgment or order, this is the two. Mainly, this is the two section two orders that you will be referring. There is a difference between Order 13 and Order 42. There is a time limit. One of them is with the time limit. So which means you have to be very careful if you want to apply for setting aside a judgment. Which one you have to follow? Because it's for Order 42, it will be include an order also. But Order 13, it only constitute to judgment only. Okay. Okay. If you refer to this case, like your own case, the judgment obtained irregularly it will be a sufficient ground by itself for setting aside. So one is it can be by itself is one of the reasons. It can only reason for setting aside irregularities of the judgment. Okay. If again, if the judgment is obtained irregular, the defendant must prove prima facie he has a defense of the merit. Okay. What is the difference between a writ and an originating summons? For a writ, an enter appearance will be a must, okay, for the party to defend his case. But then for OS, there is no need, no requirement to enter a memorandum of appearance when we serve it, when the OS will be served to the defendant. This also very stated very clear in the orders for Rule 12, okay, of the Rule of Court. Okay. OS, what is the situation? So if you see in the judgment, if in the writ, after you serve the writ to the defendant, the document that is filed by the defendant will be the memorandum of appearance. But what happened in OS or originating summons? Okay, so the party in the OS, which means the defendant in the OS, they must file an affidavit in reply, okay, and serve it on the plaintiff not less than 21 days from the date of the service of the affidavit to the plaintiff lawyers. So in other words, if they want to defend, they must file an affidavit in reply instead of memorandum of appearance. This is the big difference between a writ. Writ, you must file a memorandum of appearance, but then for the originating summons, what is the first document the defendant must file? We must file or affidavit in reply 21 days after the date of the service. Okay, and further, the plaintiff will file their affidavit in reply to be in the 14 days after the service of the affidavit if they want to reply. So which means this is the basic rule of what is the difference between when you receive a writ of summons, what is the next step that you have to file by the defendant, and if the defendant receive a OS, what is the next step that he or she must be file the document if he or she intended to defend their case. I think this is all for today. So if you have any question, you can just email to me. I will be any question pertaining to today's topic. If you get any question, you can always email to me. So that's all. Okay. Thank you very much.
Thank you, June.
Thank you, June.
Thank you.